Hi, my dragons. So now I'm here for part 2 of this week's chapter on victim rights. So now we're going to start talking about victim impact statements. And I consider these very interesting from a research point of view and from a legal point of view. To me, it's common sense that from the victim's point of view, they want people to know how they feel, what happened to them, and why they feel what they feel is just to happen in this case. And from a legal point of view, it's just really common sense to have the victim testify. To me, it's just another piece of evidence, and there's some controversy about it. When I talk to friends of mine who are working in the court systems, like judges or police officers or things like that, they don't think it has much of an impact at all, even though it's called victim impact statement. They just think that people just listen to it and go, yeah, blah, 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 and that it doesn't really have any influence. So I'd like to do some research on this because to me, it's fascinating. So the victim impact statement, or the VIS is what it's called, lets the victim let everybody know what happened to them, how they felt about it, what the costs were to them in terms of finances or emotional things that happened, or things that happened to their family, and then also what they think is fair and just for them. And this serves 4 purposes. Number 1, it helps the judges if it's a judge case versus a bench trial versus a jury trial. So it helps the judges understand what goes on. Second, it really empowers the victim. It has therapeutic effects for the victim. The victim is finally getting to stand up and say, this happened to me and I don't think it's right, and this is what I think should happen. Not that it's going to, but it's all part of it. The third thing is it educates the defendants. Okay, so sometimes offenders do things and they don't have insight into their own actions. They don't even take the victim's point of view into consideration. So that's a good way of them finally getting to see, hey, I did this, and wow, that's the effect it had on someone. So sometimes it's a big surprise to them. And then for the public likes to think, well, they had their day in court and this is fair. They got to be heard. So it has those 4 things about it that are effects of the VIS. Now, the VIS also takes 2 parts. Number 1, the written part of it, which goes to the court during the investigation and during the discovery part of the trial. So it's all in there, okay, what happened to the victim and as a result of their victimization. And 2, the second part, as we discussed previously, is the allocation, where they actually get to stand up in front of court and speak, have their say, have their day in court, okay? So as I said, the effect of victim impact statements is controversial because some people think it really helps a lot and some people think it doesn't help at all. So that's really interesting. So the research that's been done, and this is the part where I start telling you about the research that's been done about it, and then we're going to get into the application or the cases that have happened. The research that has been done is state by state. They're doing different research on it. And what they find overall is that most of the victims don't know that they can do this, okay? And then even the ones that do know that they can do it don't avail themselves of the opportunity to do it. So it's about 15% in Texas, which is a high, to overall about 10% of the victims are actually taking it upon themselves to be heard in court. So that's really a sad part, that they have this right and they're not, for whatever reasons, maybe they emotionally can't do it at the time, but they're not having the taking advantage of that right that they have. They see it as, too much time, too much energy, too much emotional drain, and then the fear, of course, is that the court won't take it seriously or do anything about it, which is very sad right there. So some of the reasons they don't know about it, if they know about it, they don't want to do it. They are dissatisfied with the way the police or the court has handled their case so far, or they think that what difference is it going to make? I'm just going to get up there and I'm going to say anything and it's not going to make any difference. Or maybe they're afraid that someone connected with the defendant might come and get them, or the defendant themselves if they aren't convicted. And they worry about their own emotional well-being as well. And I'm going to put in some pictures of what a victim impact statement form looks like, and so that you're familiar with what looks like. So we have the criminal cases, non-criminal cases, and yet to be determined about the civil cases, although there have been a few that we've talked about with the fraud and bilking people out of money kind of cases, okay? So some of the research, well, one study found that with the victim is sitting in court and they do a vis, okay, that this carried an enormous amount of weight, and it resulted in substantially more guilty sentences or verdicts than if they hadn't been there or if they hadn't spoke, okay? Other studies have found no impact of that. So you have to ask yourself, are they the same quality? Are they the same emotional types of testimonies? Because some could be dry or some could be not dry, okay? And there's a lot of questions that we're going to talk about here about this as well. Some people think that, oh, it's just a formality. Some court workers think that, oh, it's just a formality. There was a study done on parole boards that if parole boards heard or saw a victim coming to the parole hearing and then saying something to the parole board, they were much less likely to grant parole. So that's a really interesting finding right there. And another study found that if it was a capital case and the victim was in court and then did make an allocution, that death penalty was more likely to be given. So I don't know if you know anything about death juries. There is such a thing as a death jury. In other words, you have to go before the court and say, yes, I am willing to give the death penalty. That's called a death qualified juror. If you get in front of the court and you say, under no circumstances will I ever give the death penalty, then you are called death scrupled and you are removed from that jury. So there's always questions about whether that's a fair process or not in death case, capital cases. So the research that was done looked at whether or not they were death qualified or death scrupled. So any old juror, no matter what their opinion was, they found that when the victim was in the court and able to do an allocution, that this resulted in more verdicts for the death penalty. So the research is showing that yes, the juries are listening to and taking into account what the victims are saying. Again, you'd have to look at the type of this that they're doing and are they all equal, and my opinion is they probably aren't all equal. So you'd have to hold that constant if you did any research about it. So overall, in some studies that were done in Alabama, they looked at parole board hearings and they looked at the vis in Alabama at the parole boards, and they found that the vis really helped the victim, making sure that the offender was less likely to be released, and that's exactly what happened as well. In New Jersey, they looked at these sorts of things, and the Parole Board of New Jersey said, yes, they have an effect. Yes, they're good for the victim, but what they will do is clog the system. They did a calculation, and they said they made over 6,500 parole release decisions in 2004. And they said if you look at the people who work on the parole board and say, well, we're just going to look at these decisions. Let's assume that they're working 40 hours a week and they have no other distractions other than to listen to this. They found that it would be impossible for those workers to hear all of those this arguments at the parole board. So they were saying we can't do it under the current system because there's just no time for all those workers to review all those cases. Okay, so how will they do that? Okay. So maybe one of the solutions would be like an ombudsman, someone in the parole board to just hear or just review this items. So that might be something that's workable. The book didn't make any mention of that. That was just my own little, wow, maybe they need that kind of thing. So the next part that we're going to do is talk about various cases. So I want to give you a little bit of background on the cases. So you know that this was going to go to go to trial, and that you knew that there was going to be objections from defense attorneys, right? Because it is a criminal justice system, not the victim justice system. We want to make sure that the evidence is a fair distribution of pro and con, and that the juror can hear all that. So you knew that that was going to be objected to. So let's go back to the types of evidence that the juries would hear. So they hear the trial evidence, and they don't hear the victim impact statement because that would come during sentencing. So there's two types of things that they're going to hear. They're going to hear mitigating circumstances, and a mitigating circumstance is things about a crime that are understandable, like the person has a low IQ, or they've been abused as a kid, or they were under stress when it happened, or they're very young, or something like that. That's it just complicates it, okay? And then there's aggravating circumstances. And aggravating circumstances are things that people did that made the crime even more heinous than it should have been, or than it was, okay? So if you are committing murder, homicide, for money, or you're going after an elected official or a police officer, an execution style thing, or you tortured someone, or you went above and beyond, like you couldn't stab them once or twice, you stabbed them like 100 times or something like that. Or you committed a felony, you killed someone while you were committing a felony, or you committed homicide of someone who was very young, like a child or something like that, or you have already been convicted of child sexual abuse or something like that. All of those things are aggravating circumstances that make the crime even worse, and henceforth should be worth more of a punishment. So when you're doing a vis, you're looking at those two things as well. What kind of crime evidence are they here? Aggravating circumstances, mitigating circumstance. So the purpose of the vis in that case would be to show the jury that, hey, this person killed someone who was of value to the community, who was just an innocent, and they were unique and had something to contribute. And this is what this defendant did. So really, when you look at the evidence in a case, if it is a mitigating circumstance case, then they should get life in prison. But if it's an aggravating circumstance case, then they should get the death penalty. So there's a really good way to remember that. Mitigating and mercy start with the letter M. They go together. So someone has a low IQ, they have a developmental disability, or they're very young, or they've been abused. Mitigating, show them mercy. The other one is aggravating. And my thing is they both start with A. So aggravating, your ass going to be fried by the electric chair. Aggravating, ass fried. So now we'll get into the case in the next section, and you can see the play between mitigating and aggravating circumstances and the different types of cases that were important in terms of victim impact statements.